Hi everyone. So today's unit that we'll be doing is academic and research skills for law. And we're doing learning outcome. We'll be doing learning outcome 3 today, which is, I'll just bring up the slides for you. Being able to apply the skills of legal citation. But what we'll do before that is, so you've got a bit of an understanding of what we did in the last session, we look at learning outcome 2 quite quickly, quite briefly, okay? So learning outcome 2, we've looked at understanding how to research statutory law. We've looked at elements of knowledge of available websites. So we've looked at Westlaw, LexisNexis, and understanding the structure and statute of that statute. We've looked at section schedules, categorization of information in the statute, and we've also looked at understanding how to use interpretation section of the statute to check for meaning of words. We've looked at understanding definitions located in other places aside for interpretation, and we've looked at identifying where the statute initial purpose is located. We've looked at elements of key tools and resources for research in statutory law. We've looked at where to find legislation and key websites and resources for accessing legislation. We've looked at explanation of resources, identifying why a statute was created and its functions, function of a statute, structure of a statute, using interpretation section of a statute. We've also looked at identifying whether statute or section is in force. We've looked at key steps to determine if a statute or section is in force, things like locating the commencement information, purpose of a section of the statute, checking official resources, and identifying issues addressed by the statute. We've then gone on to, in learning outcome 2, looked at the structure of a statute with reference to purpose, section or preamble, commencement section, and schedules. We've looked at issues and problems statutes addresses. We've looked at how to verify if a statute, a section is in force. And we've also looked at identifying supporting material inside a statute. Things like preamble or purpose section, things like explanatory notes, schedules, interpretation section, commencement section, and transitional provisions. We've looked at issues and problems the statute was designed to address, such as the Equality Act, Health and Safety Act, and Environment Protection Act. We've looked at how to use explanatory notes and other supporting materials, such as preamble and purpose sections, schedules and interpretation sections. We've also looked at elements of schedules and interpretation section, commencement section, and why they're important and the purpose of that in regards to the acts and why there's a need to use them. So that was quickly going through what learning outcome 2 was. Now we're going to go on to what learning outcome 3 is and have a look at that. So learning outcome 3 is to be able to apply the skills of legal citation. So the indicative content for learning outcome 3 is to look at planning and structuring legal essays, how to approach problem, issue spotting or scenario-based questions using identify, define, explain, apply, idea approach or other approaches, how to identify legal issues in a problem question, using legal dictionaries and academic textbooks, report structures and report writing, how to use quotations to support legal ideas and arguments, use the Harvard or Scholar referencing system using Turnitin and reading the similarity index and acceptability index scores. So key terminology, what is legal citation? So legal citation is method is a standardized way of referencing in a specific source like a court case, statute, or treatise within a legal document, typically including the case name, volume number, reporter abbreviation, page number, and year, allowing readers to locate the source. The most common citation still is what we regard as the OSCOLA, which is Oxford Standard for the Citation of Legal Authorities, which uses a set of abbreviations and formats to address legal materials. So there's a video there that looks at a guide to legal citation that you can have a look at in your own time. It's quite interesting because it looks at the elements of how to cite legal cases. So in being able to apply the skills in legal citation. So the ability to apply legal citation skills is important for legal research and writing. It demonstrates attention to detail and thoroughness, which are essential qualities in legal practice. A legal citation refers to a specific legal source, such as a constitution, a statute, reported cases, or a regulation, a treatise, or law review. The basic format includes the volume number, abbreviated titles of the source, and beginning page or sections of that. Key aspects of legal citation. So the key aspects of legal citation include the case name, parties involved, the year, and the court identifier, the volume. The whole purpose of that is to have accuracy, make sure that everything is accurate, ensures precise location, consistency, maintains any sort of uniformity between any legal documents, and credibility, so supports the legal argument with any sort of authoritative references, accessibility, so it's available to all, to easy to locate. The citation format which uses the UK uses is the, as we mentioned, the Oxford University Standard for citation of legal authority, or Scholar for legal references. So how to cite different legal sources. So you have the legal source, which is a case reference, and you'd look at the case here. So to cite different legal sources typically include the case name in italics, the year in brackets, the court name, and the relevant report citation, depending on the style you're using, like Osco Law of Harvard, the specific formats for citing legislation and secondary legislation like journal articles. Always check your institution's preferred style to accurate practices. So, you have to check the style of what they're using. So for case law, you'd use the case name in italics, the names of the parties involved in the case, the year in brackets when it was decided, and the court name, the court where it was heard, and the report citations, so the volume number and page number for the relevant law report series. And then for neutral citations, you'd have the case name, court abbreviation, and case example, like Aaron Smith 2002 EWACA criminal. Statutes, you'd have the title of the act, the year of the act, and the chapter. And then statutory instruments, you'd have the title of the statutory instrument, the year of the statutory instrument. For books, you'd have the author, the title, and the publisher. And journal articles, you'd have the author, title, and volume number. And for websites, author, title, website date, access date, and the examples are just in the table just there on the end as well. Next slide is practical application of legal citation. So a practical application of legal citation is to provide a standardized way to reference specific court cases, allowing lawyers, scholars, and students to easily locate and access the exact legal precedents they need when researching and writing about legal matters. Essentially, acting as a unique identifier for each case, ensuring consistency and accuracy in legal writing and analysis, which is crucial for building credible legal arguments. So the first one is the citing case law. So before 2001, reference using report citations, example of the case of Carlisle and the Carbolic Smoke Wall, 1893. Post 2001 is R&A 2001. Citing statutes include the full title and secondary resources, books, journals, articles, websites cited with sufficient detail to locate that, and using pinpoint referencing as well. using example for case law sections of it. So pinpointing when citing a specific part of a case, legal citations can include paragraph numbers or page numbers to direct the reader to the relevant section. So that's pinpointing. The table for easy access, so case law pre-2001, the citation format and an example. Case law post-2001, the citation format and example. Statutes, the title of the Act and Equality Act 2010. Statutory instrument, books, journals, articles, websites with reference to citation format in the table and examples given on the side. Common tools for citation. So you've got the common tools or scholar manual, which is referencing style design for legal researchers, citation generators like Zotero, EndNote, or online generators, and legal databases that are used as well, that are used in regards to it, like LexisNexis, Westlaw, Justin One. So these are the legal citations used for elements of common tools that are used. So in conclusion, the ability to apply legal citation skills ensures that legal research are accurate, professional, and accessible. So you need to make sure that they are accessible by following the standardized or scholar format. You know, you're able to cite cases well, and there are credible sources that are used. 3.1, plan and structure various types of legal assignments. So it's really important to structure a legal assignment, and how to approach a legal assignment is typically the element of, you know, the guide that the student must follow. So, you know, you must, you know, try to plan everything dependent on what the essay is. You know, you have to have an introduction, a background, but you need to identify whether it's an essay style question or scenario-based question to answer the planning and structuring legal essays. Let's go to the next slide. Planning and structuring legal essays. So steps to plan a legal essay. So make sure you understand the question. So write down what you want to achieve. You know, make sure you understand what the question is asking you, because it's really important that you're able to understand what does it say analyze, what are the command verbs, analyze, discuss, focus on what it's asking you, research, do your research, because it's really important to do your research. Make sure you're using credible sources when you are looking at cases or statutes, and create an outline. So make sure you've got a draft in place, an introduction, a main body, conclusion, you know, and how you intend to structure your assignment as well. So it's really important in regards to that. So an introduction provides, the purpose of an introduction is to provide a roadmap for the essay and introduces the legal issues, content, define the key terms and outlines the scope of the essay and starts the thesis or an argument. And then you've got the main body, which analyzes the legal principles and applies them to the question. And then you have the content, organizes it into paragraphs and supports your arguments with cases. And then you look at the element of the conclusion, you know, and make sure the conclusion is in there and summarizes the findings. And also avoid introducing new arguments, and it highlights everything as well. So approaching problem-based questions. So problem-based questions are something that, you know, especially within law, approaching that, the most effective use is to look at the idea, which is used in regards to identifying, defining, explaining, and applying. So use that that approach, because it will help you identify the area, and also looks at elements of, you know, identify the issue, defining, explaining the principles, the legal principles, applying the legal principles, and analyzing the law and the issue around that, making sure that, you know, you are analysing the argument, you're discussing everything, you are structuring the assignment in regards to that. So use the, some people use the idea approach, which helps them, but alternative approach, some people use the IRAC approach as well, which is the issue, stands for issue, rule, application and conclusion, and which is a legal analysis framework used to structure a legal argument by identifying the key issue, stating the relevant legal rule, applying the rule to the specific facts of a case, and then reaching a conclusion on the application. So, you know, the issue could be clearly state the legal question that needs to be answered based on the facts presented. And then the R could be identify the applicable legal principle or rule that governs the issue and application, analyze how the facts of the case relate to the legal rule, explain why certain facts are relevant and how they support your argument. So that will be looking at that, and then conclusion based on the analysis. State your final answer to the legal question, summarizing the key points and clearly providing a clear conclusion. Moving on to the next slide. So let's just move on to the next slide. So the securing problems, scenario-based structuring problem, introduction, purpose, issue 1, and conclusion. And it looks at the idea and the IRAC method that can be used. Example of the using the idea model for problem-based question. So a customer, Jane, purchased a defective blender that caused injury. The store refuses to provide compensation, claiming no liability. The idea approach, the identifying which is the store liable for the defective product under the Consumer Protection Law, defining it, the relevant principles of the Consumer Act, explain the store's obligation and its purpose. So you could use cases such as Donahue and Stevenson, and then you can look applying the law, apply the facts, the defective blender causing damage, and then conclude that. So this is an example of using the idea for a problem-based questions. Practical tips for planning legal assignments. So it's really important to make sure you plan properly, because you know you need to plan when you're doing your assignment, following structures, time management. You know, make sure you are, you know, following the instructions, planning your assignment work, so time management to understand the process, collecting resources and legal terminology, making sure you are using precise and formal language as well, planning your time, focus on writing a perfect introduction, authority, supporting your work with authority, coherence, making sure that you are using, you know, a good structure to make sure that the work is in a good structure, and make sure you are using strategies in place to make sure that the work is in a good structure as well. Because that will identify how you plan your work. So the next one is the role of, so table for easy understanding. So this is looking at planning legal essays, the steps to take and the examples, structuring legal essays, the steps to take and some examples, approaching problem questions, the steps to take, use the idea, IRAC models that people are using to determine liability, and research and citation or scholar and the example. So look at that in your own time, the table in more detail. Planning and structuring assignment is really important when it comes to a systematic approach and using and making sure it has a good structure. Following the method of IDAC and IRAC ensure comprehensive structuring and enhances clarity, and make sure that your arguments are presented effectively with the exact authority. Explain the role of legal citation in academic assignments. So why is legal citation so important? So it's important to cite sources you use in your research for several reasons: to show your reader you have done proper research by listing sources you've used, and to be responsible as a scholar by giving credit to other researchers and acknowledging their ideas. So it's really important that you are doing this properly when it comes to elements of citing things. So the role of legal citation. A legal citation acts as a reference to specific legal authority, like a court or statute or regulation, allowing readers to easily locate and verify sources of information used in a legal argument, ensuring credibility and accuracy while writing and upholding professional ethics. So the first one is accuracy. So it ensures precise referencing statutes, case law, and academic materials, explanation citing the correct statute section or case supports arguments and avoids misrepresentation. Credibility: by citing sources accurately, legal professionals demonstrate the basis for their arguments and avoid any sort of plagiarisms. The explanation is proper citation. Proper citation shows engagement with authoritative legal materials such as judgments or academic commentary. Transparency: so allow readers to trace and verify the sources of information. And that's references to Donoghue and Stevenson. Academic integrity: avoids plagiarism, as we just mentioned, and consistencies, maintains uniformity. Most jurisdictions follow a standardized citation system like the Blue Book in US to maintain consistency in legal writing. Next one is how to identify legal issues in a problem question. So firstly, you would need to identify the issue. So read the scenario, identify what the legal issue is, focus on the facts of the case, spot the key facts, so you know what the legal conflicts are, and identify the relevant legal roles. Connect the facts to legal principles. So if there's any areas of laws in hand, make sure you connect it to that. Use keywords and ask questions, formulate the questions based on the scenario. So make sure you have a structure in place which is able to identify the legal issue, identify the legal principles, and identify the element of how it would work as well. So the IDEC approach to identifying legal issues, you would look at the element of the IRAC one and the IDAC one. So the IRAC is the method that provides the framework for organizing your thoughts and ideas when writing a legal issue. It's an analytical method using to dissect legal issues. So it's issue, identify, define, explain is the idea one. And the IRAC one is issue, rule, application, and conclusion, and it looks at an effective way to write an essay. Reading the similarity index and acceptable scores. So when reading a similarity index typically used in plagiarism detection tools like Turnitin, a good score is generally considered to be between 15 and 20%, with a green colour indicating a low level of matching test, usually below 24%, while yellow, orange, and red colours indicate increasingly high levels of similarities that may require further investigation, with red representing very high levels of potential 75 to 100% match. So a high similarity score means that very little of your paper is your own work. Zero similarity means that you ain't including any source-based evidence. So a requirement for many assignments is some similarity is usually expected, but not as much. So matches include direct quotes, paraphrase content on properly cited materials. So acceptable similarity scores. For undergraduate assignments, acceptable similarity scores is typically between 15 to 25%, depending on the nature of the assignment. The explanation is a higher percentage may be acceptable for assignments with extensive citations like legal cases or discussions. For postgraduate research, typically between 10 to 15%, which demonstrates originality while including appropriate references. For dissertation and thesis, ideally below 10%, reflects a high level of original contribution with properly cited sources. And then for legal problems, questions may have a high acceptable score up to 30% due to citations of statutes and cases. Legal assignments often involve quoting authoritative sources, contributing to higher similarity scores. Three tips to maintain acceptable similarity levels. An acceptable similarity depends on the school instructor and the assignments. It's best to check the similarity scores, so use proper citations, follow the OSCOLA model for all references. Again, paraphrasing is really effective, so make sure you paraphrase your work. You know, the whole point is to make sure you paraphrase your work and make sure, you know, you reduce the similarity as well. Quote sparingly, so use direct quotes only when necessary and attribute them accordingly. So don't be just putting all quotes into your assignments because it doesn't make sense and it will come up with a high similarity score. Also, make sure that you review your report, so examine your matches. Make sure you're examining the matches to ensure compliance with academic standards. And also, you know, try to avoid similarities, you know, making sure that they are between 15 and 20%, making sure they're quite low. Practical example, identifying legal issues and managing citations. So a customer buys a blender, that's an example that malfunctions and causes injury. The store claims it has no liability. The identifying legal issues, does the store owe a duty of care under the Consumer Rights Act 2015? Is the injury compensatable under negligence principles? Applying citation skills statutes like the Consumer Rights Act 2015 and reference cases like duty of care. Avoid any sort of plagiarism, so quote sparingly and provide proper citations. Example, under the Consumer Act 2015, goods must be satisfactory quality, section 9. Table for understanding. So this table looks at the role of legal citation with reference to details like it ensures accuracy, credibility, and academic integrity. The example is citing Donoghue and Stevenson, supports a negligence claim, identifying legal issues, analyze facts, spot key terms, and connect them to legal principles. The example is a defective product causing injury, raises consumer protection and negligence issues. The similarity index indicates the percentage of content matching other sources. A legal assignment may have a higher index up to 30% due to extensive use of case and statute citations. And then acceptable scores is vary based on the assignment type, with lower scores expected in the dissertation and research papers. And the legal essays is 15 to 25%, problem questions up to 30%. Avoiding plagiarism, so paraphrase, use citations correctly and quote sparingly, and quote statutes and cases accurately. Consumer Rights Act 2015, section 9. But in conclusion, legal citation is essential for demonstrating academic integrity and supporting legal document arguments. Identifying legal issues in problem questions requires analytical and a structured approach like IDEA or IRAC approach. By understanding similarity indexes and acceptable scores, students can maintain academic credibility while effectively using authoritative legal sources. So accurately reference legal citations. So making sure that your reference is accurate and making sure that you are using the right style. So in this case, it's the scholar. So make sure you accurately reference legal citations in written text using a consistent legal citation like a scholar, and making sure that which typically involves including the case name, year of decision, volume number, law report, series, abbreviation, and page number in a footnote or endnote. So you need to make sure you are consistent, always use the same citation format throughout the document, and make sure that you are sticking to the proper referencing of citations. So the next slide identifies table of contents, which looks at using legal citation, the details, using legal dictionaries. So using legal citation establishes authorities and shows understanding of legal principles. And the examples are citing cases like Donahue and Stevenson. Using legal dictionaries help clarify legal terms and principles, like Black's Law Dictionary to define negligence or other legal concepts. Using academic textbooks can provide detailed explanation of legal doctrine and theories. For example, the restitution, Jeff and Jones on restitution. Report structures and writing. So legal reports should be clear, structured, and focused, addressing specific legal issues. Example, use headings, applicable law, analysis, and conclusion. Using quotations, so use direct quotes sparingly to support legal ideas and arguments. And an example is manufacturer or duty of care to end consumers. And then Harvard or scholar referencing is a standard for legal writing in the UK, while Harvard is general for academic work. And then use Turnitin, which is a tool for plagiarism for identifying matches, maintain originality by paraphrasing. How to use legal citation in answering legal questions. So how to use legal citation. So make sure you are referencing everything properly, and make sure you are referring to the legal specific source, such as constitution. So cite authoritative sources. Primary sources could be cases, statutes, example under the Consumer Act. Integrates citations seamlessly. So incorporate citations into your text without disrupting the flow. So example, in Donahue and Stevenson, 1932, the court established the neighbour principle as a key aspect of negligence law. Use quotation marks for direct quotes. Include pinpoint references. Example, Lord Atkins stating you must take reasonable care to avoid acts or omissions which can reasonably foresee would be likely to injure the neighbour. Donahue and Stevenson, 1932. Using legal dictionaries. So legal dictionaries include words and phrases and reference tools that can help researchers understand legal terms and maxims. These resources offer information about the technical legal use of each word. And these resources generally do not offer much explanation, cannot be used as a substitute for legal interpretation of a particular term in a factual context. You have the Black Laws Dictionary, which looks at elements of, identifying things in there. Academic textbooks are really important as well, to use to understand and explain legal principles. You need to be using academic sources such as, academic books that will help you identify legal principles, but also will help you obtain, explain and understand them, but also will help you grasp certain concepts as well. So you need to be referring to academic textbooks to help you as well. Report structuring and writing. So a report structuring in this table looks at an introduction. The section is an introduction, and the purpose of an introduction is to provide an overview of the report and outlines the legal issues to be addressed. And then looks at the element of defining the scope of the report and questions the content. The main bodies analyses legal issues using statutes, cases, and academic commentary, and the content is organized into sections addressing individuals' legal issues with citations and explanations. The conclusion summarizes the findings and answers the legal question. The content, it provides a concise summary of the arguments. It can't have anything new in the conclusion. It just concludes the assignment and what it's used for. So using quotations to support legal ideas. So for example, to highlight critical judicial reasoning or statutory languages, the quotation example given is that the law requires goods to be of satisfactory quality, and that's Consumer Rights Act 2015, Section 9. How to use quotations, effectively. So, how would you use them in elements of, identifying why there's a need to use quotation marks? So why would you use quotation marks? So it introduces the quote. It's used to indicate that you are not repeating, that you are repeating someone else's words, but they're used to set off titles or to work. In academic writing, you can use single or double quotations marks depending on the referencing style, and they are used in regards to try to enclose a direct quotation. So that's a repetition of someone else's words. So an example in here is the in negligence law, Lord Atkins stated the foundational principle, and then in quotation mark, you must take reasonable care to avoid acts or omissions which are reasonable foresee would be likely to injure the neighbour, which Donoghue and Stevenson, 1932. And then the next slide is looking at, Harvard and Oscola referencing. So Harvard system referencing is not the same as Oscola referencing. Harvard is the name and the date style, while Oscola is a numeric style that uses footnotes. So Oscola is the Oxford University Standard for Citation of Legal Authorities and is edited by Oxford Law faculty. Oscola enables you to quickly and easily cite legal resources such as cases, and it's a numeric style which uses footnotes as opposed to Harvard, which is the name and the date. So, there's a difference between both of them. They're not the exact same in regards to, identifying the difference between each one. So the Harvard system uses the name and the author and the date of the publication in the bibliography. Reference are listed in alphabetical order by author, as the Oscola uses a superscript number to refer to a footnote which contains full details of the source. In the bibliography, all references are listed at the end of the work. Oscola, as we mentioned, is the Oxford University Standard for Citation. It's used by law students to cite legal resources like legislation and cases. Different referencing styles may be used in different disciplines. And for example, APA is an author-based used in psychology. It's important to be consistent with your referencing. You should check what your referencing is used by the institution. So as you've got on there, the Oscola gave us examples of cases, statutes, and books, and then Harvard referenced gave examples of books and journal articles that can be used in regards with some examples. For example, a book would be McKendrick under Harvard referencing, McKendrick 2022, Contract Law 15 edition, Oxford University Press, and then journal articles, how they're written as well, and how they are different to Oscola ones. So using Turnitin. So Turnitin is the whole purpose of Turnitin, and as we go through, is to detect plagiarism. So Turnitin is there to empower and protect, is a program which checks for your originality of your work. So, you know, your work looks at, it searches through its database and published texts, web pages and student assignments to see if there are any areas which have significant match to your work. So plagiarism is not a plagiarism detector. Your tutor should use plagiarism to alert them to possible problems. Most familiar with writing, with literature, and using your experience. So you can't rely on Turnitin in regards to, it detects where the work has come from, so it reviews it and it flags it up. And it's, you know, it is a plagiarism prevention tool that compares submitted writing to databases sources. So it shows the similarity report, shows the percentage of similarity between your paper and other sources, and it shows this in a breakdown of percentages. Paraphrase, so avoid copying text directly, rephrase ideas when citing for a source, you know, so make sure you are rephrasing everything as well, because when it comes to your assignment, do not copy and paste things. Understand acceptable scores, so maintain similarity scores with acceptable limits, so 15 to 25% for legal essays. Practical examples, so original submission, negligence requires a duty of care, and revised submission. So Turnitin is often integrated into classroom assignment tools. So when you're submitting on Moodle, they will have Turnitin, that your assignment will be uploaded automatically through Turnitin, and it's there to improve academic integrity and to check any sort of plagiarism that students can, you know, it's there to detect stuff. So it's really important that you use it properly. So this table, for easy understanding, we looked at legal citation, the details, we looked at Oscola and Harvard referencing, we looked at legal dictionaries as well, defined terms or concepts, and with reference to examples, Black's law for negligence. We looked at academic textbooks and how they provide in-depth explanation of legal doctrines, and we used the example of Contract Law Book by McKendrick. Report structure, use clear sections, introductions, main body and conclusion, and include headings for each legal issues, using quotations to support arguments with judicial statements, and then referencing formats or Scholar or content dependent on Harvard, or which is consistent referencing dependent on your institution, which one they use, and using Turnitin to ensure quality of the work, originality, and paraphrasing properly to cite certain things. So in conclusion, to learning the element of Turnitin and legal writing, referencing is really important for legal writing, ensuring credibility and the effectiveness of legal arguments. By using and formatting using Oscola and Harvard referencing, you are employing tools for Turnitin. Students can produce high quality work, and they are adhering to the academic standards, because you will have, as an institution, any institution, and an example, UK Varsity would have an academic policy in place on plagiarism and how that applies as well, and why that would be academic misconduct if you collude your work, or if there's any sort of work that you've copied another friend, which is colluding, or taken chunks out of a book as well. So now we've finished learning outcome 3 on academic and research skills. I'll just give you a recap of what we've done in this session, a summary of what we've done, in this session, so you've got a little bit of an idea of what we've covered. We've looked at elements of being able to apply the skills of legal citation. We've looked at planning and structuring legal essays. We've looked at how to approach a problem using spotting a scenario-based questioning using IDEA or IDEC approach, and also how to write legal issues in a problem-based question. We've also looked at using legal dictionaries and looking at how to cite different legal sources like case law, statutes, books, journals. We've also looked at elements of practical application of legal citation. We've looked at common tools for citation like Oscola, citation generators, legal databases. We've also looked at planning and structuring legal essays. And we've looked at the structure of a legal essay, approaching problem scenario-based questions. We've looked at alternative approaches like the IRAC approach. We've looked at structuring problem-based questions. idea. We've looked at elements of the role of legal citation and academic assessments. We've looked at how to identify legal issues in a problem question and the IDEA and IRAC approach. We looked at the similarity index and the acceptable scores within Turnitin. And we've looked at elements of maintaining acceptable similarity levels. So using proper citations, paraphrasing, quote sparingly, review your report. We've also looked at elements of accurate referencing legal citations in written text. We've looked at how to use legal citation in answering legal assessments, and also looked at using legal dictionaries and textbooks and why they are so important to use. We looked at using quotations to support legal ideas and why we use the quotations and why they're used effectively. We also looked at in detail our Harvard system and our scholar referencing system and how that works. Then finally, we looked at using Turnitin and the purpose of Turnitin and how it's used effectively. So paraphrasing, reviewing, and understanding your scores as well. So that was what a quick summary of what we've done in Learning Outcome 3. These are the references for Learning Outcome 3 that we've used as well, so you can refer to them. Again, additionally, you have referred to ebooks and journals on the Moodle for this unit. Further reading, there's a link there on referencing, a guide to referencing that you could look at. And there's also Learning Outcome 1 to today's Learning Outcome 3 will be recorded and put on Moodle for you to have a look at, to listen to if you need to, with help and to reference when it comes to doing your assignment. Any questions you have or any sort of queries you have about anything, please email learnerwork@ukvarsity.co.uk. So now we've finished Learning Outcome 3. The last Learning Outcome is Learning Outcome 4, and then we've got the assignment discussion. Thank you for attending today's session, and I will see you in Learning Outcome 4. Thank you.